We have, in fact, taken into custody without incident James and Jennifer CRUMBLEY, the fugitives involved in the Oxford incident.
Hi, buddy. Father calls the police station as soon as he heard about the shooting, saying, "I think it's my son who's doing it." Well, if you think it's your son who's doing it, right, then doesn't that show that you should have known that your son might have the capacity to do it prior? That's going to be the argument of the prosecution. On the day of the shooting, this shooter had his gun in his backpack and began drawing pictures of shooting up the school. This really disturbed one of his teachers. His teacher pulled the paper from him that he was drawing on and turned it over to the counselor, and the counselor called the parents, and the parents came in and they were discussing, hey, your son has some serious psychological, serious mental problems. We want him to be safe. We want the school to be safe. We need you to take your son home right now and get him immediate mental treatment. The parents declined. Now, this is where it gets interesting. Now, if the parents didn't know he had a gun, if the parents didn't know he had any access to guns, that would be one thing. But prior to this case, just a few weeks before, the mother went out and purchased a gun specifically for her son. This is the first school shooting case where the parents are being charged with negligence. There's actually a lot of firsts in this case. For instance, this is also the first school shooting case in America where the school shooter was charged with terrorism. Last Monday, the shooter has pled guilty to the shooting. And this has majorly affected his parents' case in a lot of ways. The parents were going to rely on their defense that their son was insane. And now, in order to put in that guilty plea, their son had to do a withdrawal from his insanity plea. The parents have a lot of uphill battle for them. For one, they fled the scene. The father called the police station as soon as he heard about the shooting, saying, "I think it's my son who's doing it."
At my house, there's an active shooter situation going on at the high school. My son goes to the high school. I have a missing gun at my house.
If you think it's your son who's doing it, right, then doesn't that show that you should have known that your son might have the capacity to do it prior? That's going to be the argument of the prosecution. Mother texts the son, Jennifer texts the son, please don't do it, when she hears about the shooting. And why is this important? Well, the parents are not being charged with murder, right? They can't be charged with like first-degree murder, for instance, because they were not the one pulling the trigger. They didn't have any malice aforethought. When you're going to be charging someone with a crime, you need to have something called the mens rea for that crime. And for murder, you need to have, it depends on the level of murder, but for first-degree murder, in most states, you need to have malice aforethought. So in other words, the desire to kill the person, even if it's just a split second, but prior to doing it, you have to have a moment of consciousness of wanting to have that person dead and then doing the action that leads to the person's death. Well, the parents here had no want for these children who were killed for them to die. It's just that they're being charged with they're being charged with involuntary manslaughter. In this case, they're going to have to show negligence. Negligence is when you don't do an action that you are required to do. So you owe a duty to somebody, and you don't do an action leading to the harm of that person. So a good example of this is parents are responsible for their children, and you could be a negligent parent by not feeding your child, for instance. Now, you're not required to feed every child in the world. However, you have a duty to your child. And every time you get in a car, your duty extends to more people. What the prosecution is claiming here is that the parents were negligent in their duty of care to the students of the school, because when they purchased the gun for their son, or at least when Jennifer purchased the gun for their son, they created this risk of harm. What the defense is going to try to do here is they're going to try to say that there's no proximate cause. So what is proximate cause? So with negligence, you have to show that there's actual and proximate cause. So the actual cause would be the mother purchasing the gun, the son having the gun, and then the gun going to shoot the people. The inability to act, the inability to recognize that their son may have brought his weapon to school that day when he was called into the counselor's office, the inability to recognize maybe that their son had a mental illness or was depressed or had a desire to shoot at the school, and then to continue to buy him weapons, or the negligence in not securing the gun. That's another issue that came up in court. The son recently admitted that the gun was not secure and that he had access to it the entire time. So the prosecution here is going to have to show that the proximate cause of the harm to the death of these 4 children was because of the negligence of the parents. The son's journal is extremely disturbing. The jury is going to read this journal, and they're going to have negative thoughts towards the defense. But we don't know whether or not the parents actually read this journal. So I would find it extremely prejudicial with very little evidence added to whether or not the parents knew that their son was depressed, which is the element of the case which matters here. If the 2 defendants, the 2 parents, decide that they're not going to work together anymore, but they're going to point the finger at each other, well, then those attorneys can no longer work together, right? Like as they're doing right now.
I am going to represent Ms. Crumbly, and my partner is going to represent Mr. Crumbly, so that we can keep our arguments clean and separate.
So they'll have to separate, and what they'll have to do is have no more communication with each other. So that's the Chinese wall, and that's really difficult. It's a very interesting professional responsibilities question, whether or not you're capable of separating facts and not having attorney-client privilege broken when 2 attorneys work in the same firm or work close to each other. Now, if I were the father of the case, I would not be working with that wife. I would be pointing my finger at her so hard. I would not want my attorney to talk to her attorney. I would want complete total separation from her. In fact, I would want a totally separate trial from her. Another just fascinating part of this case is the son, he can be called to testify. And he can be called to testify by either the defense or the prosecution or both. Let's continue watching this case together, and maybe I'll do a live next time that there is a court date. Put a comment below as to how you think the outcome of this case is going to come, and let me know what you think. All right, thanks for checking out Lauren De Laguna. Say bye, boss. Bye, boss.